Hello, this is Matt on the Moon Family Sedan channel. I want to share with you some of the latest thoughts from attorney John Deaton. He points out, well, a number of very interesting things, including the fact that we have to stop a particularly destructive narrative that's frankly being pushed by the SEC. And we have to protect the secondary market. That's the overall message. There's a lot of other very interesting stuff inside of his latest thoughts in this thread that's all up on the Twitters. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so I would like to note, this starts with attorney John Deaton retweeting something from his crypto law organization. It's a sharing of the amicus brief that was filed in the lawsuit. It's pushing for a class action lawsuit, which predates the SEC v. Ripple lawsuit going back to like 2018. So this is the, what's it called? The Zakhanov lawsuit. I think that's the name right here. But anyway, so I haven't had the time to do anything more than browse this document at some point, but I'll be happy to have a separate standalone video to go through this if there's a sufficient interest, and I think that you guys probably would be. But I always love seeing attorney John Deaton's arguments and how he breaks things down. So anyway, he was sharing that, and then that sets the table for all of his additional comments. So check this out. Here's what attorney Deaton said on Twitter. The secondary market must be protected. I filed a motion asking the judge for permission to file an amicus brief in the civil class action lawsuit versus Ripple, which was filed in May 2018. My motion and the attached proposal amicus brief are below and on crypto law. The reason I filed the motion is the same exact reason I filed a similar motion to the library case and why I fought so hard to become amicus counsel in the SEC v. Ripple case. Secondary market transactions. We have to stop the narrative that software code is a security. Bitcoin, ETH, XRP, etc., standing alone, are nothing more than alphanumeric sequences, math, digital code, software. The token itself is not a security. A token, like any other asset or commodity, can be packaged, marketed, offered, and sold as an investment contract. All types of assets or products have been offered/sold as an investment contract with the promoter. In Howey, it was orange groves that were packaged, marketed, and schemed into an investment contract with the W.J. Howey Company. The parcels of land and the oranges were never the security. So the Howey test. Imagine somebody, and I love this example, imagine someone buys an orange grove from the Howey Company, sits back and relies on Howey to do all the work, and then the buyer gets his pro rata share of profits. We can all agree the above scenario meets the Howey test and was an unregistered securities sale. So now hypothetical. So check this out, because this is where you take it to the next step. And the simple concept destroys the SEC's position. So check this out. John Deaton writes, hypothetical. Now imagine the person who purchased the orange grove directly from Howey dies. His estate sells the land, the orange grove, to a new buyer who has never heard of the Howey Company and knows nothing about the circumstances surrounding the original sale. No credible argument can be made that the secondary sale of the orange grove qualified as an investment contract with the Howey Company. Any regulator claiming that the secondary sale of the orange grove was also a sale of a security would be laughed at. So pause. Think about how obvious that is. That's what John Deaton said there is not controversial. It's 100% accurate. But you know, when you look on the surface here, how the SEC, what the SEC is arguing about regarding secondary markets, the way that they're approaching all of this, without comparing it to something like that, it doesn't seem necessarily, to some people anyway, as absurd. Make this comparison to anybody that doesn't think that it's absurd. It's going to quickly become clear because it's a perfect comparison. Now, obviously, no, as far as I'm concerned, and I'm sure I'm preaching to the choir here, now to us it does look absurd, even without this specific comparison. You can kind of see, obviously, we don't know Ripple, the company. But then if you apply it to previous case law and how that would be handled on a go-forward basis, in terms of secondary market sales of orange groves, well, it's pretty damn obvious. That's why what the SEC do, it's just, they're so disingenuous. They are asshat pricks. Attorney Deaton continues. In other words, the orange groves, tracts of land, forever remain tracts of land, even though it was sold as a security. Through the years, since Howey was decided, many assets or commodities have been packaged or schemed into an investment contract. Condos were packaged/schemed in a way that, when it was sold by the promoter, it was an unregistered securities offering. Whiskey was used as an investment contract. Whiskey remains whiskey. Chinchillas were offered and sold in a way that satisfied the Howey test. Maybe the best example is that beavers were once schemed into a scenario that caused the sale of beavers to be an investment contract, also known as a security. Regulators didn't go around calling beavers securities. Yeah, and by the way, as far as that one, to the best of my recollection, it had something to do with, it was some sort of like breeding program to where you could buy into it and then the beavers would be sold at a later date. It was something stupid like that. But the point is, like, that's one of my favorite examples, because beavers, again, not securities. They are beavers, right? But still, they were found to have been part of a scheme and so it's the totality of the scheme surrounding the beavers. That was the investment contract, not the beaver. The beaver wasn't the security. So that's why, like, obviously it's never the underlying asset, whatever it is. And the SEC knows this, but they want things intentionally as vague as possible so that they have maximum prosecutorial abilities. Let's say they can swivel and sway anywhere they want to go with it, so they can argue it. That's why they want things as uncertain as possible, so they can argue whatever fits what they want to push in the moment. It's awful. And then Attorney Deaton says, the Howey test doesn't change for crypto. I missed this line. He said, but what about digital assets? Are they different? The answer is no. The Howey test doesn't change for crypto. In fact, in 2013, there was an SEC case and Bitcoin was sold as an investment contract. And after that case was decided, guess what happened? Some people at the SEC and others started saying that Bitcoin itself was a security. Now, that's interesting, too, because I didn't recognize... So, look, I did know that there are people at the SEC arguing that Bitcoin itself was a security back in the day. I was aware of. This 2013 case, I don't know anything about it, and I didn't find out about this until very recently, and it's thanks to Attorney John Deaton. So I'm curious, actually. I'll have to look into it further here. But Bitcoin still itself obviously isn't a security. And so anyway, Attorney Deaton says, listen to this 4-minute clip of former commissioner and Stanford law professor Joe Grunfest. He explains, sometimes Bitcoin will be a security and sometimes it won't. And that's a quote, by the way. The argument was that investors expected a profit and were relying on the efforts of Bitcoin miners, so Bitcoin was a security. People forget or ignore the fact that the Howey test is meant to be applied to specific transactions, not the underlying asset. An example of a specific transaction is ETH's ICO. Everyone can agree ETH's ICO passed the Howey test. If Satoshi would have sold some of his first Bitcoin and the buyer didn't do any mining himself, but just sat back and waited for the price to go up, it meets the Howey test. Even had Satoshi sold Bitcoin early on, it wouldn't mean Bitcoin is a security. If Ripple offered/sold XRP as a security, so what? ETH's ICO was an unregistered securities offering, but it doesn't mean ETH is a security. In an investment contract, the underlying asset is not a security. Yet Gary Gensler and the SEC keep focusing on the token itself, calling the vast majority of cryptocurrencies themselves securities. The problem is that smart, influential people, other than Gensler, are pushing this false narrative that tokens themselves are securities. Listen to Michael Saylor in his discussion with Raoul Pal. Saylor is a rocket scientist, so I have to believe that he knows what he's saying is not accurate. XRP is software code. Even if Ripple sold XRP in an unregistered securities offering, it doesn't mean XRP is a security. I filed a motion asking to file an amicus brief in the civil class action case because the plaintiff's attorney is asking the judge to certify the proposed class to include all XRP purchasers who acquired XRP from May 3rd, 2017 until the present day. The proposed class is not limited to direct sales of XRP offered and sold by Ripple or its executives. The proposed class includes all secondary market transactions. The only way all sales can be included is if the asset itself is a security. It's an absurd position. There isn't a single case in 76 years where a court found an investment contract when there wasn't any privity at all between the buyer and the seller. There is not one case that has found a subsequent sale of an investment contract to also be a security. And so, folks, that's why I'll say again, even if Ripple actually loses, if they actually lose the lawsuit against with the SEC, even if that happens, you wait till an appeal happens. Because and upon appeal, you get to the appellate level, and that's it. This is where Ripple's genius plan here, in terms of the way that their person's case would really play out. And so I don't know if Ripple's going to lose. I'm not saying that, but I'm saying if they do, it's how could this not be an obvious slam dunk? Like this is a key point. You know, because there's if you're talking about transactions for which there is no contract, secondary market sales, it's obvious. There is no question there. And so that's why I think ultimately, even if it takes extra time, even if there has to be an appeal, well, there you go. Anyway, and then Attorney Deaton says, I'm taking the same position in the class action against Ripple as I did in the SEC v. Ripple case and in the library case. I take no position regarding any claims regarding direct sales made by Ripple. Litigate your heart out. Prove the case against Ripple. I don't give a S word. Same with library. I have nothing to say about direct sales by library, but claiming secondary market sales independent of the founder/promoters also violate the law is insane. Saying the token itself is a security, or it is the embodiment of the security, is intellectually dishonest. On top of everything, the lead plaintiff in the class action case is a day trader who bought, owned, and sold XRP all within 2 weeks, 5 years ago. And so, pause. It owned and sold XRP all within 2 weeks. How can you possibly argue that you were reliant upon Ripple's efforts to increase when you're day trading and you're holding it for that? It's such garbage. It makes you wonder what the real intent is behind all this stuff. It doesn't make any damn sense. And then Attorney Deaton says, he said when he bought XRP, he was relying on the efforts of Ripple because they promised to get financial institutions to use XRP. I point out that if he truly was relying on Ripple's efforts, he wouldn't have sold it within 2 weeks. Disputing the half-century legacy banking system known as SWIFT might take more than 2 weeks. He's bringing this class action on behalf of all XRP holders in the world. I point out the class I have is 75,980, while he has 6. Regardless, I tell the judge his case should be limited to sales offered directly by Ripple and shouldn't include secondary sales around the world, including in foreign lands where those regulators say XRP is not a security. Golf clap for Attorney Deaton, everybody. Absolutely killing it. Pushing back against the bogus narrative. This needs to be more widely understood by people. So I am going to, I just don't have time today, but I am going to read through this entire amicus brief. So I'll be happy to cover it in a future video. I always love seeing what Attorney John Deaton has to say and the arguments he puts forth here. And you know it's going to be pure fire, just like always. But I wanted to at least get out some of Attorney Deaton's thoughts, since this is brand new stuff, literally just from yesterday evening. So keep fighting the good fight, my friend. I love seeing it. I'll go ahead and wrap up here, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.